Okay, here we go. Chapter 8. I hope you're not getting as tired of seeing me as I am getting tired of doing these videos, but they're a good replacement for not being able to have actual classroom, which I prefer. You may not, because you can sit in your house, in your room, and watch these. Okay, Chapter 8 has to do with intellectual property rights, a lot of which is over my head. I never practiced in this area. It's a very specialized area, and people who do this, basically that's all they do. We have a lot of 64 slides, probably about 44 more than we need. So when I see a slide that's not that important, I'm going to kind of go over it quickly, because really in this preview right now I want to tell you that there's about a half dozen to a dozen major points that I want you to get from this chapter and sort of commit to memory without going into a lot of depth on a lot of this. Okay, so intellectual property is defined as any property resulting from the intellectual creative process, the product of one or more individuals' minds. Okay, so that's the definition. This was understood as being extremely important by our founding fathers. And in Article 1, Section 8 of the Constitution, they said that Congress was authorized to secure for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So statutory protections actually began in the 1940s. Okay, so it should be obvious why this is important, but the reason it's important is because if you spend time and maybe money and resources inventing something, whether it's a product or a song or writing a book, whatever it might be, if you cannot collect profits from it because somebody else can take it and they can collect profits from it, then you're not going to be encouraged too much to produce that intellectual property. So by protecting that property right, we encourage inventions. So it's as simple as that. So we begin with one type of intellectual property, which is a trademark. And a trademark is a distinctive mark, motto, device, or emblem that a manufacturer stamps, prints, or otherwise affixes to the goods it produces. It's a source indicator, meaning it tells you where it came from. This is important not only to the producer, but more so probably to the consumer, because consumers, at least even the most basically knowledgeable consumers, usually buy things that they're familiar with, that they can feel comfortable that they're getting what their expectations are. So it helps to avoid consumer confusion. Okay. Trademarks identify a product, and protection of the use of the mark protects those products. The owner's investment in goodwill established by the product, as I just said, and it protects the consumers. It's not constitutionally based, and states may have their individual laws regarding trademarks, but it is federally protected. So the Lanham Act creates incentives for companies to invest. It prevents unjust enrichment of companies who infringe on trademarks. By the way, if you don't know already, and that probably means that you don't watch the news very much, one of the areas of law today that is very intensive, I guess would be the word, is with intellectual property and foreign countries. The United States is known historically as one of those countries that has invented and produced new products, and unfortunately there are other countries that like to steal those and not pay proper royalties through licensing to the owners. Okay, so the Lanham Act, when it was revised in 1955, created a private cause of action. What that means is, we've never really talked about that before, but in some situations only the government can sue an individual in a civil matter. But in some instances, the law, the statutes give the right not only to the federal government, but to individuals. And that's what we call an individual cause of action. And so you can sue if somebody violates that. Famous marks such as McDonald's, Dell, and Apple are protected, and we don't want people to be confused by something that copies that or is too closely similar to confuse the public. So in order to win a private cause of action against a violator of your trademark, you have to show that the mark is famous and distinctive, that the defendant has begun using the mark in commerce or allegedly diluting the famous mark. The similarity between the defendant's mark and the plaintiff's mark gives rise to an association between the marks. That association is likely to impair the distinctiveness of the famous mark and gives rise to a cause of action. So I'm going to have to fix that, which should be plaintiff's mark, not Amos mark. Okay. You need to register generally with the U.S. Patent and Trade Office, and you can renew it between the 5th and 6th years and every 10 years thereafter. The symbol to protect yourself is this R inside a circle that gives constructive notice to the world that the mark is personal property. And applicants cannot submit an application to protect that right that's already been given by your filing for that registration. You can register your mark if it's currently in commerce, or if you intend to put it into commerce within 6 months. And that registration allows you to use that symbol. It has to be distinctive, or if it's not distinctive, it has to acquire a secondary meaning. What is a secondary meaning? A classic one would be Kleenex, okay? Kleenex originally was a brand name, okay? But when you say, hand me a Kleenex, you're not necessarily saying, hand me a tissue paper that was made by the Kleenex company. It's become it has a secondary meaning now, and that is a Kleenex, meaning a piece of tissue usually used for wiping your nose or that kind of thing. Okay, so marks can be trademarked if they're trademarks, which is a distinctive mark, symbol, name, word, or motto, or device that identifies goods. Or it can be a service mark. In other words, it doesn't deal with a product, but deals with a service and distinguishes that service. Or it can be a certification mark that verifies the level or quality of the good or the geographic origin of the good. So if it's coffee from the mountains of South America, that may be something that you can get a certification mark for. And finally, a collective mark, which is something that's used by an organization, a cooperative, or an association. So in order to dilute the mark and to infringe upon the owner's rights to that registered mark, it doesn't have to be an identical use as long as it's similar and it is likely to confuse the public. And especially if it's competing in the same market. Okay. So if it's copied or wrongfully used, you have a right of action against that individual or corporation for infringement. And your registration has put those people on notice on a national level. So what are your remedies for trademark infringement? Any profits that the violator has accrued as a result, any damages to your reputation or business. The court can order the destruction of those goods that mislead the public, and the court can grant an injunction keeping the other business from using those fake goods with that registration mark. Okay, so we're going to stop there with part 1 of chapter 8. For chapter 8, your magic word is patent, P-A-T-E-N-T. Patent is the magic word.